Muhammed, thank you so much for being here once again.
My
Our
pleasure.
beloved Humble Village is honored to have you, a dear friend of Privacy Village, and who's an expert in the EU legal system. So, I have some questions today, but again, dear audience, if you have any questions, please just jump in and ask your questions. But without further ado, Mohammed, can you introduce yourself?
Yes, exactly. So, hello everyone. It's a pleasure to be here to support this cute, nice, good project that Mertcan is building. As he said, I'm based in Brussels. To maybe so I'm a lawyer in one of the largest international law firms, especially dealing with AI legal issues. I'm the AI work stream owner here in the Brussels office. And as you can imagine, being in the Brussels office, being based in Brussels, brings a lot of challenges with its role as the EU capital. Therefore, I am also highly interested, and I work with AI at the same time. My story, just to give me a bit of a background about the AI Act, because I'm not really a fan of saying that anyone is an expert of the AI Act at this stage because of its novelty, and because I know how large companies, the very largest tech companies, are still exploring the legal text and trying to make sense out of it, including the regulators in the AI office here in Brussels. So it's a community activity to to make sense out of it. So no one is really an expert. But yeah, it's correct that I have worked on it as much as possible. At this stage. And my story with AI goes a bit in the past, back in 2022, when it was a proposal by the European Commission. I happened to work with some colleagues who were advising the co-rapporteur of the AI Act in the European Parliament. So, and at that stage, our specific contribution was about the fundamental rights impact assessments, basically insertion of that into the legal text during the trilogues when the parliament was reviewing the text and proposing suggestions. And then I moved on to the private practice, and then the text went through its the development phase and became a final legal binding text in the EU legal system. And then we are now slowly implementing it, starting with the general purpose AI models. And now, yeah, basically, I worked on the when it was a project, and now it is a reality, and I still work on it. And yeah, it's interesting because it's world's first AI law, and we will talk more about it today.
Thank you, Mohammed. And
Let me fix myself. Let me correct myself because it's not world's first AI law, but rather horizontal AI regulation in the world.
thank you for the fix. And we're looking forward to hearing from the trenches. I'm just gonna let people in. Sorry, guys. And yeah, without further ado, I'm just gonna go with the questions. And my first question
Please
to
do
you,
so.
Mohammed, is beyond safety, for the people who are not really 101. Beyond safety, what are the primary legal objectives and regulatory spirit of the AI Act?
Yeah, very happy to answer that question, Merchant. But before that, I would like to, I would be really super happy if you could jump in and just drop your questions on the floor so that we can all discuss, because I know the culture of this event and it would be really great to have that interaction. I try to say that in all events where I speak, but a lot of times people don't react during the event. So if you want to,
So
please
the
proceed forward. Anytime, just
veterans
cut
here,
me.
please do. Tess, Sude, Beray.
Yeah,
You're
whatever you wanna ask, really. It's a Friday night for me. So it's I'm up. I'm in the mood for such a chat. Yeah. So the AIX regulatory spirit beyond safety. Yeah. First,
yep.
the safety term safety is a really American term. I happen to hear that often from American clients when they're talking about concerns in relation to AI. But in Europe, I would say it's rather limited, in concept, and the AI Act is truly more than that. So as you know, the AI Act transcends conventional product safety regulation. and it is more about the EU's fundamental commitment to democratic governance, human dignity, rule of law, and etc. And actually, the Article 1, the first article of the AI Act, articulates four principal objectives. I think there is one on transparency and safety, indeed. One on promoting innovation. We can debate that if you want. Protecting fundamental rights and establishing accountability. So the regulatory spirit extends definitely deeper, anchored also in the Charter of Fundamental Rights of the European Union. So the fundamental rights aspect is definitely there. And this is actually quite interesting because this represents a philosophical departure from EU's purely technocratic product safety regulation, for motor vehicles, for I don't know, for kitchen robots and etc. There are a lot of regulation in the EU, and they are all product safety regulation. And the AI Act is also partially a product safety regulation, and it was proposed initially as a 100% product safety regulation, but it ended up being also a fundamental rights, rule of law, etc., regulation. So the EU basically explicitly refused to defer AI governance to market powers or to corporate self-regulation. Kind of also recognizing maybe that democratically accountable institutions must maintain uh, primacy over technological power. So there is that. When you look at Article 5, we have prohibited practices. So no whatsoever, they are not allowed in the EU. You cannot deploy or develop any of these AI systems. And we have like things like manipulative subliminal techniques and social scoring systems and discriminatory biometric profiling and etc. And when you look at that list, you will see that they are not prohibited just because they are safety hazards, but also because they are inherently contradictory to EU's values of human dignity, rule of law, equality, and democracy, and etc. And I mentioned fundamental rights impact assessment, the same thing there. And interestingly, there is even like environmental protection in the AI Act regarding the carbon dioxide used to train and general purpose AI model. It needs to be disclosed by the model providers to a certain extent. Of course, people, or let's say that everyone is trying to disclose as little as possible, but it is there. It was taught. So it is more than safety. If that is the good answer to start with, let's go with that.
Thank you, Mohammed. Lovely answer. And like with your current work, uh, where the company's at right now? So like we're seeing like model cards, data sheets, etc. And like you said, like the carbon, etc. The environmental impacts of these LLMs, etc. need to be transparent and such. And do you, in your day-to-day job, handle these stuff like model cards, data sheets, and such, or more in the policy
Uh,
side as a lawyer?
no, it's not on the policy. So the policy topic, I work partially also on the policy side, government relations, but it's more like 10 to 15% of my job. Because exactly because the before AI Act was finalized, this was understood as a policy issue. But now we have a legal text, and moreover, we have the code of practice. So that's also like maybe a soft law instrument, but still it's going to be the basis of enforcement for the European Commission, for the larger providers, for the providers of general purpose AI models. And where are the companies now? So we need to probably differentiate between different types of companies. But if you're talking about providers of general purpose AI models, so the biggest ones, most of them, if except one or two, have signed the code of practice. They are preparing the documentation required, such as the data sheet, the annexes of the AI Act, and technical documentation, user instructions, and etc. But it didn't start to apply it. They will need to do it by this summer, if not updated. So as you know, there's also the digital omnibus package, all the discussions in relation to that. But they are actively, yes, they are actively working on it. The training data summary, also one thing. And as you might imagine, because some things are rather vague, everyone is trying to understand and kind of like to balance the risks and the expectations on what should be included and what shouldn't be included in these documents that will be published. So they are. It's also really a brain exercise besides a legal journey.
It should be
So
fun.
they're there. And with regard to deployers, like the companies who are deploying AI systems and etc., they are generally asking for their qualifications, and it's not very straightforward always. Sometimes what we have seen, I have seen an interesting situation that there is a company providing HR services and who is going to deploy a model, but the model actually is going to be used by the customers of the HR company. So in that scenario, who is the deployer? Is it the customer? Is it the HR company, and etc.? So it is there are legal questions to be dealt with, and we deal with them. Besides qualification, there's always the risk analysis. What is the risk classification of a specific AI system? That always comes up.
I was gonna get to that, so let me ask my second
All right,
question, please.
let's go, because I can talk forever. So
Yeah, I know, and we can listen to you forever. So, for time limit sake, I'm just gonna go with the questions. And how should we interpret the risk-based classifications, just the ones you mentioned, especially for complex multi-use systems, like just like the HR example you just gave, and such?
Yeah, so risk classification is definitely a significant interpretative challenge, I would say, under the AI Act. As you know, so that maybe to take a step back and explain people who are not super familiar with it yet, the AI Act has a multiple layer classification model. So you first look at whether there is an AI system actually in place, because we have also observed sometimes that a tool that is marketed as AI doesn't really have AI within the meaning of AI Act, because in order to have that AI system definition in reality, the shortest shortcut is to have some sort of machine learning involved with the technology. And sometimes it's not rather machine learning, or it's not, it doesn't really capability to infer, so make that those specific capabilities that AI systems have, but rather complex algorithm, but that's not really AI. So there's that, you look at that, and then you look at prohibited practices, then you look at whether that can be high risk, and then you look at whether there is limited risk, Article 50, so there are some transparency obligations, and etc. And for multi-purpose systems, what matters is really the intended purpose. Let's say that there is, I don't know, there's a biometric recognition system with profiling features. So multiple things, doing multiple things. The provider should be drafting an intended purpose. And if that intended purpose includes biometric recognition, then it's a high-risk AI system. So it really depends on how the provider positions the product into the market. And that's exactly the reason there is a specific article in the AI Act 25, which says that if someone basically changes the intended purpose of an AI system, they become the provider of the AI model. So if Google tells you that you cannot use your model for human CV evaluation, and if you do that, well, congrats, you are a provider of a high-risk AI system now. So yeah, it without even realizing. But if you ask me how they are going to enforce this, that I don't know. But it's how the legal text works.
Yeah, it remains to be seen. And like lawyers are here, as far as I know, the majority are lawyers, and the majority of us will be dealing with deployers rather than providers in our day-to-day jobs. So again, just as a rule of thumb, what are the general obligations for deployers of AI systems? Can we have a
right? Yes, we can mention. But maybe let's ask the audience if someone wants to say something or ask a question. I'm very happy to interact.
Dear audience, Nargis, you have your camera open, so like the eyes are on you right now.
Thank you so much both for this very useful session. Marjan, it was a very good question actually, because I, as a practitioner, was wondering how we use that for deployers of AI systems. Generally, I was actually gonna ask your interpretation of the different risk systems and risk categories. And like, let's say you're a general counsel in a company that provide, I mean, everyone uses AI right now, right? So most companies are now deployers. So from a compliance perspective, what would be the first step that you take to be compliant with the EU AI Act as a counsel for a company that deploys AI? What are the main things that we need to be aware of? I guess that's the main question in mind.
All right,
If you can.
good question. So I would split it into two: the AI compliance and the other, legal, ethical, reputational concerns. So for the first part, let's start with that. Companies are often, they want contractual risk analysis. So they want to know what are the IP terms, what happens to input data, what happens to feedback loops, do we own the output, what happens if we combine the output, we are writing code with AI. Let's say that we have written 80% of our software with AI. Can we claim, IP rights over our software, or because like let's say there's an artistic company using AI. Again, the same thing, can copyright be claimed and etc. So they are more interested in those. For some questions, there are not yet answers, but there I think the talent of the lawyer comes in to suggest some recommendations, such as like one of the things that we advise is, especially when writing code, is really record and change the output a bit, even if it is a bit. Do not allow it to be 100% machine generated, so that there's human involvement, so that the copyright protection can be claimed to a certain extent if if there's a problem in one day, and etc. Terms of use, sometimes terms of AI models prohibit certain things. So employees should be aware of that. So they summarize and make it super basic for employees to understand those terms. That happens. They sometimes compare providers to understand which offer more favorable terms. That is something that happens quite often. To sum up, that's the non-AI Act part. For the AI Act part, if a deployer is asking us, and it happens indeed, that what should we do? First, what is your use case? I mean, where are you going to use the AI? Is it just Gen AI, or are you deploying a CV evaluation tool, or are you deploying a performance evaluation tool? I need to know that so that I can tell you. Although most are not, the AI Act doesn't apply to existing systems because of Article 111, 111. It will be applicable in the future for the updates of that specific model. I do the risk qualification. After that, if it is high risk, then what you should be doing is already, to a certain extent explained by the AI Act, Article 26, such as the human oversight, make sure that you comply with providers' instructions, inform your workers. You may need to conduct fundamental rights impact assessment, although the scope is limited and depends on the type. For what else? Like, I think you should be monitoring. I'm just talking from my mind, so I might be missing out things. But if you want to revisit the article, it's online. Monitoring system operation and reporting anomalies, and so you have a set of obligations, and that's what you should be doing under the AI Act. And for non-high risk AI systems, we have Article 50, limited risk, or people call it limited risk. The legal text doesn't. It's for certain AI systems, there are transparency obligations, and for deployers, if it is generating text, audio, or image, there is a specific transparency requirement. If it is emotion recognition system, there is a specific transparency requirement, and etc. That whole coverage basically explains what the companies should be doing.
Thank you, Muhammed.
Thank you.
Of course.
Dear audience, any questions, or should I continue with my own? All right, I'll continue with my own for the time being. Mohammed, what is the extraterritorial reach of the act, and how does it impact the global operations? Let's say a deployer in Turkey, etc.
Yeah. Well, as long as a deployer in Turkey or a deployer in Turkey, yeah, I was provider. So for a deployer of Turkey, I don't think that for non-EU, let's not limited to Turkey. The AI Act will not be applicable unless the output is used in the EU. So if a provider, let's talk about the provider, because for deployers it's not going to be very relevant, except for I am aware of certain companies, and they tend to be large international companies, which to a certain extent apply AI principles or obligations in non-EU jurisdictions as a basic like a benchmark, just as we had for the GDPR. So it's very similar to that. For providers, as long as you provide the output in the EU, you put your name and trademark on an AI system, and it can be bought or used from the EU, you are in scope. Good luck. Something that people maybe miss out, I find it interesting. So in the EU, we have the Copyright Directive, and under the Copyright Directive, there is a text data mining exception. So basically, providers can use any data online unless there are conditions. I'm simplifying it. Unless the right holder opts out in a machine-readable format. And recently, there were discussions whether that would apply, when the provider is doing the training outside the EU. Let's say it's happening in South Africa. And then, and there's a recital, and the guidance and the discussions have, evolved into a direction that, yes, it applies. So wherever you do your training, you should still respect EU copyright law, so that there's not competitive, like a regulatory arbitrage situation, and etc. So that's those extraterritorial, application considerations influence, of course, outside the EU. And it will be the case if the AI extends and becomes, workable.
Yep.
Or stays workable, let's say.
All right. Thank you for the answer. And what changes are proposed to the AI Act through the recent Digital Omnibus?
All right.
But before that, if you want, there's a question, I suppose.
Yeah, it's a comment, I guess, for users. Copyright is not clear in all cases, whether we can use output for commercial use or not. Let's say, yeah, I mean, to my knowledge, and I have checked a handful of providers' terms and conditions and assisted some to draft. They are either clear. I think they are clear, but they are sometimes hard to find, because for some tech companies, they have thousands of documents online, and it is hard to spot where the terms that you are looking for sit in their website. That is a challenge. But once you get there, I haven't really faced a scenario where output ownership was not clarified.
Thank you, Mohammed, and thank you, Nagis, for the question.
Yeah, and the Digital Omnibus,
yep.
Right? I should continue from that. Yeah, first, it's a bit ironic, because AI Act is a new law. It's partially applicable, partially not, and then EU is trying to change that. But it happens. It's politics. It's the world. It's the changing dynamics and etc. And the Draghi report and all of that. So what is proposed? First, I will start with the thing that the proposed update that I really don't like, the AI literacy requirements. So in the current version of the AI Act, the deployers and providers should basically train their employees and staff on the risks of AI, how to use AI, what AI is capable of and what not, and etc. And in the proposed amendments, they switch that to into a burden for the member states and the commission rather than the companies. And I find it really disappointing because I think it really, from a societal perspective, it really sparked the movement. It encouraged companies. There wasn't a sanction tied to it, by the way. It was a legal obligation. It is still, but to be seen if it will change. It really sparked the movement. Companies invested in it, and they will not probably have the same, the appetite for it if it goes away. So I don't really see the logic there. But yeah, there's that. For providers, so when you're analyzing whether AI system is high risk or not, if you decide that you identify that it's not a high risk, you had to register that into an EU database. They propose to remove it, and commentators and academics find it dangerous because it kind of opens a loophole to get out of high risk qualification based on non-tested or non-publicly available arguments. There's some proportionality adjustments for obligations for SMEs, the smaller companies. There is time delay, applicability delay provisions for high risk obligations like 18 months to 24 months and etc. And then there's a piece on enforcement that the AI office, the one that sits within the commission, will have more supervisory powers for AI systems that are search engines or AI systems that are built by a general purpose AI model provider and etc. So it's also expanding a bit. But does it really change much? No, I think it's people expected that the AI would change a lot, but in the end, the proposed changes to the GDPR are much more significant. And from an AI perspective, it's 95% is there and it's going to remain there. Although I don't know, I have seen that also France is pushing for a larger revision of the AI Act. So who knows?
Thank you,
This is the
Muhammed.
current situation.
And for those spirits who are building games that teach AI literacy, should we go on with our journey, Muhammed, in full throttle?
Oh yeah, of course. But I mean, I think some companies will keep investing in it. And you can also debate whether a legal obligation in a legal text where there is no sanction for not complying would really create an effect or not. But maybe I'm biased because I sit in the lawyer, the chair, and clients come and I deal with those questions, and I dealt with the companies who ask that questions. So I have the image that it sparked an interest and it encouraged companies, but maybe not. Maybe that's my biased opinion. But I don't think that's the reason for you guys to quit, your projects and what you are doing.
Nah, they can't stop us, mate. What are and I'm jumping to the next question, but before that, actually, Tess has some comments or questions. Let me read that out loud. She said, AI literacy read to me as more standardized annual training.
Yeah, I think it's, yeah, so that's correct. And data protection trainings are the same mostly, but it really depends on the appetite of the company. I have seen companies which are willing to tailor and deliver multiple AI trainings to different segments of their staff. So there would be a general basic one. There would be a more specific one for the engineers. There would be a workshop for software developers and etc. So it really depends on what is prioritized in a company at the same time.
And then she went on, streaming platforms and social media use AI to moderate user-generated content, detecting hate speech, copyright violations, harmful content, etc. When does content moderation AI become high risk under the Act? Does removing user access to platforms based on AI decisions trigger high risk obligations around human oversight and appeals?
Okay, that's nearly a legal advice question. Yeah, so content moderation, and I will talk from on top of my head, so please forgive me if I make a mistake, but I don't think content moderation would be high risk under the AI Act. It doesn't ring a bell, and I think I'm to a certain extent familiar with the text. But what you should be looking at is automated decision making under the GDPR, because if using AI leads to blocking access to a service, the ADM guidelines indicate that that is ADM, and it should be only happening with the consent if other exceptions do not apply. So we are more entering into territory of the GDPR there rather than the AI Act.
Thank you, Mohammed. Tess, if you have any follow-up questions, please type it in. Nope. Thank you for the question. So I'm jumping to my next question then. What are the specific compliance burdens for general purpose AI and foundation models?
Right. So for GPIA, let's differentiate between the model and the system. So a foundation model that is not it appeared in the AI Act at a certain time, but in the last version we don't have it anymore. It's all called general purpose AI model or system. For the GPIA model, it's the actual model, that the engineering piece, the black box, the model that provides the predictions and does the research and etc. For them, for the providers of models, there are a lot of compliance obligations, basically technical documentation, copyright compliance, the training data piece, and enabling access to documentation for regulators and the training data I have talked about. So those type of, and once you exceed the territory of 10 to 25 flops, so yeah, when you become a systemic general purpose AI model provider, general purpose AI model with systemic risk provider, there are additional obligations like the red teaming, adversarial testing, more robust cybersecurity, reporting incidents to AI office. Yeah, that's what I can tell. And for the system providers, and this is an important differentiation because it often, so basically 2% of the companies in the AI scene are the actual model providers, and 98% are the packagers, those who take a model, either fine tune it or apply RAG methods to make it more suitable for specific use cases such as CV evaluation. And then you see the name and the trademark and etc. They are the GPIA system providers. So they don't really have any. They might have very limited obligations, but they don't really have much. It's the model provider that matters. But the balance there is if you fine tune or modify a model to 1/3 of the flops used, and if it's a bit maybe too technical, then you become the provider of that modified part of the model and etc. And then the obligations, the heavy compliance obligations, kick in upon you. So yeah, is that a good summary in a nutshell?
As always, thank you. And the last two questions on my end. How will the European AI Office and national competent authorities handle the enforcement? What do you envisage around the...
I believe, and I have written that also on LinkedIn, that the problem with the AI Act is really the enforcement, and it's generally with the EU tech laws, because it's not centralized. And the reason it's not centralized is the treaties, the founding treaties of the EU, which distributes competence between member states and the EU, and fundamental rights related topics are not under EU's competence. Plus, product safety is enforced by the member states as per those treaties. The only thing that is truly centralized is the competition law, basically. So because of these legal foundations, the member states often end up having enforcement powers, and then they start interpreting the text, and there are differences, and they see things differently. And there is the AI office in Brussels enforcing certain parts of the text. So it is challenging, as you might understand, when you have 27 member states plus one AI office. And actually, for smaller countries like Malta or others, I have heard in a room here that Malta, or it might not also be Malta, or it might be one of the Baltics as well. One of these countries have 6 people dealing with the AI Act, the Data Act, DGA, the NIS2, and etc. So it's barely possible that they even enforce it to one or two companies. So there are also those human resources challenges associated with it. What is going to happen? I don't know. No one knows. But I hope they make it work to a certain extent. I'm a lawyer. It would be beneficial for me that they make it work, so that that there is a law that is enforced. But am I too hopeful on that? No, I don't think so. I think there will be serious challenges with enforcement.
Thank you, Mohammed. And the last question: what is lawyers' role in relation to the AI Act? As like Osman Gazi Güçlütürk was one of the speakers at the event, and like in one of our prior talks, he said like in GDPR, a lawyer's role was around like 60%. The rest was technical. Now it's down to let's say 30-40%, and like 70 to 60% are more on the technical side. Do you agree with that? And plus, like, what's your take on the lawyer's role?
Yeah, I mean, I don't. Let's start with what I don't agree with. I don't agree that it's a full lawyers thing. I don't agree that it's a full technical engineers piece. So it definitely sits somewhere in between. Legal counsels and lawyers, external counsels do significant work on AI Act, such as an engineer is not going to take a legal definition and guidelines and compare it to a system. So AI system qualification, risk qualification, role qualification. How does it all play out? When do you become, when you're a deployer, what is forbidden, what is not, and what you should be doing? All of these things are lawyers, legal counsel's duties. More than that, all the preparing the technical documentation as AI Act wants, the building human oversight mechanisms, AI literacy, what else? Like all these things, and building and keeping up to date an AI systems inventory. These are all dealt with lawyers basically. So I agree that there is all these things. We do it. I see legal counsels doing it, and it will be there, and it's going to remain. Yeah, we are not going to fix bias on training data sets. It's because we are not qualified to, and that's perfectly normal.
Thank you, Mohammed. And the audience, if you have any questions, now it's your last chance. But before that, so there's this team in the festival called Battle for AI, and there are actually two teams where the participants who would like to attend to that background game choose a team, and the teams are AI fundamentalists, which are more like transhumanism and more AI will flourish humanity kind of vibes, where the opposing team is AI apocalypse, where basically the AI will be the doom of humanity. So I ask each speaker which team they are on, because that team wins 100 experience points, Mohammed. So which one are you on? Will AI? Yeah.
You're asking me.
Yeah. What's your take on it
Okay.
in general sense? And
I'm more of an enthusiast.
The fundamentalist one then.
Yeah, but fundamental, I think it's a bit counterintuitive, because fundamentalist may also mean a person who is very focused on the protection of fundamental rights. That's how it's understood in Brussels, so that they are really hesitant on new technologies. That's more of.
All right.
That's why I get a bit confused.
That's a different take from Brussels. Yeah, never thought of that. But all right. So more optimistic side.
Definitely. Yeah.
All right.
Because I simply like tech. I like using it. I think it's useful at the same time. I use it to make budgets. I use it for analyzing, which is not very GDPR sensitive, my health results, and getting simple advice and holiday planning, destination scanning, etc., etc. For legal research, I think there is room for growth because the hallucination is, that's a risk for any professional activity, but for the legal industry, we cannot afford a hallucination in a client advice. That's a scandal. That's going to cost me my job. So I cannot trust AI in that regard yet.
So
But for other things, it's perfectly useful, and I like it.
I have a follow-up question with regard to your latest comment. So with regard to legal tech, especially like LLM-driven legal tech, let's say Harvey, etc., were
Yeah.
those on your radar at any point? Have you had like a demo or such? Is there any tool that you vetted and use, or in a general sense, like you just said, in legal sense, they're not reliable? So I'm keeping
So
my hands off.
Harvey, our firm is now piloting Harvey, but I didn't have access. We have an AI tool, a general purpose AI tool that is approved. I use that at my job, and for my private use, I use Perplexity because it has access to multiple models. It's basically an AI marketplace, and you can choose the model and etc. Currently I like Anthropic for deep research function, and I like GPT's last model for any other thing, basically for gathering data and etc. But for legal, I really don't know. I don't know the hallucination rate of Harvey. I don't know how they prevent it. I didn't look into it, but yeah, I think if there is a certain risk of hallucination, which I understand that it will be there, I think lawyers will have a hard time fully employing AI for legal research. They might take it as a basis, the first stage research, with the condition that you confirm every piece of information. Then the usefulness of AI becomes questionable when you confirm every piece of information on an output.
And
so legal is a hard industry for AI, but
exactly.
there are all other industries which are much more promising.
So we need more than these tools to become GPT rappers and such, and really have some dedicated training done for lawyers' sake. And none of those tools are doing that. So I think we still have to wait a little more as legal folks
Probably.
to use it in our day-to-day job. So that's it, everyone. Thank you so much for being here. Fun fact, it's my birthday today. So that's kind of nerd
Happy
I
birthday.
am. Celebrating Data Privacy Day with dear friends. So thank you for being here. Our next event will be on career gamification, but not as you know it, on Monday. And on Tuesday, we have AI governance roles and career paths. So stay tuned and take care, everyone. Thank you for being here once again. Muhammed, it was a pleasure as always.
You too.
Thank you so much, man.
Thank you so much for inviting me.
Always.
Have a nice weekend, everyone. Bye-bye.
Take care. Ciao.
Thank you.